Second speaker today is one quick announcement. I don't know, Jordan let me know that we have a special opportunity today, so I hope you'll join us after 4 p.m. for a very exclusive tour of the Dean's office up on the top floor. I hear this is a really rare opportunity, and even Jordan, who's been a student here for some time, hasn't even seen the Dean's office. So we hope you will stay with us. As you probably know, this building was the former Bullock's Wilshire department store. Has a long storied history in LA, and we're very pleased that it's been preserved. So with that being said, I'm going to move it over to Amy Minteer, and I won't read her whole bio. You have it on your paper, but Amy is a current trustee of CPF. She's also a partner at Chatton, Brown & Karstens. She's worked extensively on CEQA litigation, and she earned her Juris Doctorate from the University of Michigan. So I'm going to turn it over to Amy, and she's going to cover the basics of CEQA.
Okay, which the one with the arrow is forward.
The middle one is forward.
Oh,
or I'm sorry, the bottom one is forward,
and
the middle is backwards.
Got it. Okay. All right. So I'm going to kind of take a step back from Susan's presentation. She was talking about cases and what laws were developed from them. I'm going to kind of go through the process of CEQA in general, and where appropriate, discuss how some case law has interpreted that. What do I need to point it out?
The bottom button, you might need to press it. There's always
Oh, there we go. Okay. Well, as Susan mentioned, CEQA was adopted in 1970, and it was modeled after the federal law, NEPA, which we'll touch on just briefly at the end here. And CEQA is made up of Public Resources Code sections, and then also the California Resources Agency has adopted guidelines that implement these sections of CEQA. And I always like to recommend to, especially community groups that are getting into CEQA a lot and wanting to address it, getting one of these either from CELSOC or the Association of Environmental Professionals. It's got the entire CEQA code and guidelines in it. I like the AEP version because it has a really good table of contents, or I'm sorry, I'm blanking on the word. Yeah, a very good index in the back. That, you know, if you're interested in an issue, you can look it up there and then go to the code section. So CEQA's purpose is to address adverse physical changes to the existing environment. And they do that by requiring an agency to go through a process when they are approving a project that may have such impacts. And there are several components to that process, the overarching components to it, and then we'll kind of step through what that process specifically is. But the important parts of CEQA are its disclosure component. In the environmental review document, the lead agency is required to disclose what the project is, what impacts it might have, potentially mitigation measures, alternatives to the project. They're also required to disclose all portions of the project and what permits might be needed, potentially from other agencies other than just the lead agency. And then also where members of the public can go to get more information about the project. The CEQA process is intended to identify the specific or the significant impacts that a project might have. And then if there are significant impacts, to identify ways to mitigate or avoid those impacts. And then public participation is a real overarching goal of the CEQA process. Courts have repeatedly interpreted CEQA in ways that promotes the public participation in the process. For example, there is a case that says you can't just hide something in an appendix to the EIR and then rely on that as the basis for approving a project. You need to really disclose that information to the public as far as why an impact is significant or isn't significant. But ultimately, an agency can approve a project that has significant impacts if they've done this full disclosure, identified the impacts, inform the public, and allow the public to participate in the process. Well, you guys have the, I don't know how visible that is up there, but you have the handouts. This is just kind of a chart that shows the who participates in the CEQA process, a basic overview. You know, there's the project applicant goes to the lead agency with their project, and the lead agency is the public agency that has the principal responsibility for approving the project and for conducting the environmental review for the project. It's usually pretty obvious. It's usually, you know, the city or county where the project is. Every once in a while, it gets a little hazy when there is a project that kind of straddles the line of two jurisdictions, and there can be a disagreement as to who should be the lead agency, but that doesn't happen very often. Then there are also the responsible agencies. Sometimes with a project, a city would approve a CUP for a shopping center development, but there's going to need to be some additional approvals from other agencies in the future. For example, this new shopping center is going to cause so much traffic that there needs to be a new ramp on the freeway. So Caltrans is going to need to approve that freeway on-ramp, and they would be a responsible agency in this instance. They would rely on the environmental review that's done by the lead agency, but they would subsequently approve their portion of the project. There are also trustee agencies, and these are specific state agencies with jurisdiction over resources that are held in trust for the people of California. And this includes the California Department of Fish and Wildlife, the California Department of Parks and Recreation, the State Lands Commission, the University of California, and the California Coastal Commission. And with these agencies, the trustee agencies, the responsible agencies, and then also other agencies that have jurisdiction over some aspect of the case or some impact that the case might have. For example, SHPO, when there's a historic resource, they have jurisdiction over historic resources within the state. And so the lead agency should consult with them in the preparation of the environmental review document. And then the other participants are the environmental or the EIR preparer, which this question comes up a lot. Who is required to prepare the EIR? The lead agency can do it. The applicant can actually do it as long as the lead agency certifies that they have reviewed and considered, and it's their independent judgment that they agree with the findings of the EIR. Or the lead agency can do it in-house, or they can hire consultants to prepare the EIR too. And then, as I mentioned, the public is a very important component of CEQA, and they also participate in this process by commenting on projects, by suggesting mitigation measures and alternatives. And I also have the courts on there because that can come up as well, as you saw in all the cases that Susan showed earlier. When the dispute continues despite a project being approved, it can go to court then. And CEQA, while it has a short statute of limitations for getting into court, it does have a good basis for helping the public address these issues quickly and thoroughly. Okay. So this is a CEQA process flow chart that OPR put together, and this is a portion of it. I found it's kind of helpful in determining how and when CEQA applies to use the flow chart. And so, the first question in looking at this is there a project that CEQA would apply to? And as an initial matter, if a lead agency is just going to deny a project, CEQA is not required. So that's, then it would not apply. But if they are considering approving a project, then the CEQA would apply to a discretionary project. And discretionary versus ministerial is we'll discuss that in a minute, and I think Susan gave a good discussion of that as well. But what does project itself mean? And that's an activity that may have an impact on physical impact on the environment, and historic resources are considered part of that environment that could have an impact. And it includes not just the direct impacts, but indirect, reasonably foreseeable impacts. For example, if an update to a general plan is being approved, that's going to change what the land uses are allowed in different areas. It's not actually physically changing what's happening on the ground, but it will have an indirect impact in the future, and those impacts need to be analyzed in the environmental review document. And that's part of the CEQA project that needs to be studied. One case that wasn't discussed earlier that is interesting in this aspect is the case of Martin versus San Francisco. And in this case, there were proposed alterations to the interior of a existing single-family home. Everyone agreed the home was a historic resource. That wasn't in question. But the only impacts were going to be to the interior, and it was a private home. The public did not have access to it, and there was no way for the public to see into the home. And so in this instance, the court found that because there's no public access to what is happening, that isn't part of the environment that's being impacted by impacting the interior of that home. For there to be an impact to the environment, it must be physically perceivable by members of the public beyond the private individual proposing the project. I have seen this case be used by agencies to say that interior never needs to be analyzed. That's not what it said. If it's an interior of a public building, that's different. That's publicly, it's physically perceivable by the public. If it's something where there are large windows that everyone can see into the building, I would argue that that is also part of the environment that should be analyzed for purposes of CEQA. So Susan talked a little bit about the tension in cases as far as what is discretionary and ministerial when it comes to historic preservation and demolition permits. And just a general definition of discretionary versus ministerial. Discretionary is a project that, when being approved, the lead agency needs to exercise some type of discretion has the ability to exercise its own judgment. It's not just a checklist of, do they meet the building code? Do they have a certain setback? It's much more subjective than that. Whereas a ministerial project, it just uses fixed objective standards. And while there is tension between the Friends of Juan Briones case and the Friends of Gill Street case, one thing that they looked at is whether, or the Friends of Juan Briones case looked at, was whether there is the ability of the lead agency to put any conditions on the project, or whether they have the ability to deny the project. And so that's something to look at because they looked very specifically at different historic preservation ordinances that dealt with demolition permits. And it seems like that's what courts are going to do it on a case-by-case basis of what these ordinances say. And so something to look for is whether there are whether the lead agency has the ability to put conditions on that demolition permit, as far as whether it's discretionary or ministerial. And in general, CEQA has stated, not in the historic preservation context, but in discussing discretionary versus ministerial, that CEQA in general favors environmental protection. And so if it's a close call between discretionary and ministerial, it should be considered discretionary and go in favor of environmental review. I'll just touch on this briefly because Susan covered it, and CEQA requires that the whole of an action be considered. And when there is both a ministerial and a discretionary approval that are part of a project, like a ministerial demolition permit, but you're putting in a large housing development that requires variances and other discretionary approvals, together they need to be considered discretionary for purposes of CEQA. And this is part of the reason that CEQA requires a detailed project description so that it's clear what all of the components of the project are. It's not just ministerial aspects that are before the discretionary is happening, but if there's anything ministerial after the fact, that should be considered as part of the whole of the project too. And I'm just going to remind you guys there are statutory and categorical exemptions to CEQA review. Statutory exemptions are those that the legislature just decides that a project, regardless of whether it has environmental impacts or not, should be exempt from CEQA review. And categorical exemptions are for classes of projects, not specific projects like the statutory, that the resource agency has determined generally don't have an impact on the environment. And so in general, they don't need to do CEQA review. But that is also why, in addition to the categorical exemption, there are exceptions to the categorical exemption where it's an unusual situation where something that would normally not have an impact does have an impact. For example, building a single family home is a class 3 categorical exemption. In general, just building a single family home, not a big deal. There's not going to be environmental impacts. But if you're building that home on wetlands, that's different, and you need to consider the impacts associated with that. And as Susan mentioned, there is a specific exception for to categorical exemptions for a project that can cause substantial adverse changes in the significance of a historic resource. And there's a local case on point on this that addressed, or that dealt with this, that our firm worked on, the Committee to Save Hollywood Land Specific Plan versus City of Los Angeles. And in that case, the historic walls in the Hollywood Land area, they were designated resources, and a neighbor who lived next to them built a fence on top of these historic walls. And the city approved it without CEQA review. And the court found, well, no, that has the potential to impact a historic resource. You need to do environmental review before approving it. And then also relevant is that courts have found that if a project requires mitigation measures, then a categorical exemption is not appropriate. So if an agency is approving something with a bunch of conditions to eliminate impacts, for example, they are going to demolish part of a historic home, but have all of these conditions on what needs to be left in place and what what can be touched and what can't, and the design that needs to happen after the fact. That needs to be evaluated through the CEQA review process. That's something that you can't just rely on a categorical exemption to approve. So once you've determined that there is a discretionary project, there's no categorical statutory exemption that applies, then the type of environmental review document that's required should be evaluated. And lead agencies use an initial study to evaluate this process. It goes through all the different impact areas and asks the agency to look at whether there's a potential impact that would be mitigated, or there's no potential for an impact in each area. And this is a preliminary analysis that the agencies should use to determine whether they should use an EIR, a negative declaration, or a mitigated negative declaration. And here's a little plug for the community folks that I always like to remind people. You can request notification of any type of CEQA notice that's coming out. For example, when there is a notice of an intent to adopt a negative declaration or an MND, or there is a notice of completion of an EIR that you can comment on. Before that, if you have any inkling that a project's happening, you can send in a request to the agency that asks for a copy of all CEQA notices relating to a specific project, or if you don't know the name of the project or it's unclear, put in the specific address, put in as much detail as you can so that they will know what you're talking about. And at that point, they will be required to provide you with notice as it comes out so that you're notified and things don't just get approved without anyone knowing. And then the 30-day statute of limitations to sue goes by very quickly. So there are the 3 types of environmental review documents: the negative declaration, the mitigated negative declaration, or MND, and the EIR. Oops. And one point on this, it depends on whether a project's going to have significant impacts, which type of environmental review document you use. And in determining whether there will be significant impacts, the agency has to use what is called a threshold of significance. And they're allowed to set those thresholds of significance. Oftentimes they rely on established standards, like for air quality, particulate matter of 10 tons per year is a very specific standard. Some areas it's whether something is going to have a significant impact and what the threshold should be is a little bit more of a gray area. Something we've seen in several instances is with historic districts, and what is the level of demolition that can occur to the district before it would exceed the threshold of significance and it would become a significant impact. I would argue that if you're demolishing anything that's a contributor to or part of a historic district, it should be considered a significant impact, but there are agencies that see that differently or have argued for that in a different way. And as Susan set out earlier, the standard for whether an EIR or a negative declaration MND should be prepared is the fair argument standard. And that is when it can be fairly argued based on substantial evidence in light of the whole record that the project may have a significant adverse effect, an EIR is required to be prepared. And I'm going to go through in a little more detail the environmental effect part with regards to historic resources, and then substantial evidence as well. So to get a little more specific from the cases that were discussed, Public Resources Code section 21084.1 sets out 3 categories of historic resources. If a resource is listed in the National or California Register, it has to be considered a historic resource under CEQA. It's mandatory. If a resource is listed in a local register or a historic resources survey, then it's presumptively a historic resource under CEQA. The agency would have a high burden to prove that it's no longer should be considered a historic resource. The category that the cases Susan was addressing earlier dealt with is this discretionary category. That's when something is not on any register, it's not in the survey, it's not locally listed. These are resources that are outside the mandatory or presumptive categories. But CEQA says that even if something isn't listed, it can still be considered a historic resource. And so the real question is, what is the standard for determining those discretionary resources as to whether they are historic or not? And I think that's, as Susan mentioned, not a completely answered question. The recent cases that she was discussing said that, well, it's not the fair argument standard, but it's some other substantial evidence type standard. It would be the only impact that required a substantial evidence standard for, instead of the fair argument, to determine between negative declaration and EIR in that case. CEQA defines what impacts to historic resources are, and they say that that's a substantial adverse change in the significance of a historic resource is the physical demolition, destruction, relocation, alteration of the resource or its immediate surroundings. And so that's something that we like to remind agencies of, that it's not just when you demolish a historic resource. It's if you put a massive structure next to a one-story historic resource, you're really impacting the setting, and that can have a significant impact on the resource that needs to be evaluated. CEQA also defines materially impaired to be demolition or materially altering those physical characteristics that convey its historic significance. So in a lot of instances, that's considered to be the character-defining features. What are listed as the character-defining features when something's listed on a register, those are the features that, if they're damaged or altered, are usually considered to be a significant impact. And just briefly, archaeological resources are also considered, they're considered in the historic resources sections of CEQA. Impacts to those resources need to be considered as well. And CEQA specifically says that preservation in place should be considered. It's not required, even if it's feasible, case law has said, but it's something that if there are archaeological resources that are going to be dug up as part of a site, that preservation in place should be considered. And I don't know if that's something Deborah might be addressing as well. And also just a brief note on this, AB 52 was recently approved, and it addresses impacts to tribal cultural resources, which are different than just historic resources and archaeological resources. This can be a connection with a certain natural feature, and the legislature recognized the connection that Native Americans have to the land in defining tribal cultural resources as a broader category that needs to be analyzed under CEQA. And they also require consultation with tribes that are known to have an association with sites. So that was addressing impacts, the significant effects that a project might have when looking at the fair argument standard. But you need to determine whether there's substantial evidence. You can't just say, well, I think this is a bad project, you need to do an EIR. That's not adequate. There needs to be some type of substantial evidence. And so CEQA defines that as facts, fact-related reasonable assumptions, which means that you can draw some conclusions on facts. I'm not immediately having an example come to mind, but also expert opinion. But that expert opinion has to have some basis. For example, we were working on a case where an expert says, well, you can reduce the water usage if you were to put in, or in a normal project, you can reduce water usage if you were to put in native landscaping. But they didn't look at what the project was at issue, and the project already had native landscaping. But the applicant was saying, well, look, we've got this study that says we can reduce our water usage by 50%. And that was an expert opinion, but it wasn't based on facts that were relevant to the project. And then sometimes lay opinion can be considered substantial evidence, particularly when it comes to aesthetic impacts. Sometimes personal observations are helpful. If there is an intersection where every day you have to wait 10 minutes in order to make a right-hand turn, that's an objective amount of time that you can document and provide that information, and it could be considered substantial evidence of a traffic impact that would be worsened by the project. And then, other agencies frequently comment on projects, and their comments are well received by lead agencies and courts. So this is another plug for community folks of just how important it is to make the record in in a CEQA case because that's all that a judge is going to be looking at during litigation. And so you look to the community, look to the internet, look to sources within your area that you can use as substantial evidence of an impact. You know, always having an expert is great, but it's not always possible. Taking photos is good. That can be very helpful, but I would caution everyone to date them and submit them with a declaration. Came up for me in a case where there were photos submitted, but the judge said, well, we have no idea when these photos are from, so we can't use them to show that there was a tree at that site at a certain date. Also, review the local surveys when it comes to historic resource impacts. I work with a couple of organizations in Palm Springs, and for a while, the city had done a local historic resources survey, but they weren't really looking at it when they were coming up with projects that would impact these resources. And so we would always just go to the survey, point out that they've already looked at it, found it to be a historic resource, and so any impact to it should be considered significant. When we pointed that out, they would agree, but wouldn't always look before then. A brief summary of what's included in a negative declaration. Usually there's a 20-day comment period. It's pretty short. The agency isn't required to respond to comments that are submitted on a negative declaration. Recently, I've seen a lot of them try to do so because if evidence of impacts is being put into the record and they're not responding to it, it just bolsters the case for there to be an EIR required. So this graphic kind of shows the threshold of significance as we talked about earlier. And there's an action that's going to have a significant impact. You put in the mitigations and it goes below that level. And a relevant factor, a couple of relevant things that this chart includes. What the baseline conditions are is an important consideration, and those are what the existing, in general, are the existing conditions on the site. The Supreme Court recently confirmed that that is generally what should be considered the baseline, what's happening at the site when the project's being proposed, unless it would be prejudicial or wouldn't give appropriate information to use those conditions. And that's the Neighbors for Smart Rail case. Also of note is if a previous owner or even that owner had years before done some illegal activities on the site, filled in some wetlands. That's the existing condition that you come to when you're looking at the project. And so you don't get to go back before those illegal activities. Unfortunately, it's problematic because it can encourage bad behavior. For example, and this comes into play in historic resource context. Sometimes folks will allow a historic resource to get into a really deteriorated condition, and an agency may find that it's no longer should be considered historically significant. That's just something to be aware of. It's not always going to work if that's what's being proposed, but that is something that is done. And then also, with regards to mitigation measures, CEQA does not allow for deferred mitigation. So you can't say, well, yes, this project is going to impact this endangered species habitat. But after we approve the project, we're going to do a study and see just how bad the impact's going to be and what we should do about it. And we'll follow whatever that study says. You can't defer that analysis. You can't defer coming up with those mitigation measures until after the project approval. And that's because of CEQA's public disclosure focus. The public needs to be aware of exactly what these impacts are. They need to be able to have some say in whether those mitigation measures are going to be effective or not. So if there is a fair argument that the project may have a significant adverse impact, then an EIR would be prepared. And there are lots of different types of EIRs. I don't think we need to go through all of these, but something that you may see, if an EIR has already been approved for a project at that site that's similar to what's now being proposed, a supplemental EIR can then be prepared if you're going to change it in a way that could change the significance of the impacts. For example, the site had 3 historic homes on it. They previously proposed a project that would demolish one of those homes and build around it. They're now proposing to demolish 2 of those homes and build around them. They can do a supplemental EIR to rely on the analysis from before and update it with new analysis. Something I've also been seeing a lot of lately are addendums to EIRs. That's when there's no new information of significant impacts that is being included. And that one is interesting because it doesn't have the same public review process for an addendum. There isn't a comment period for those. So again, getting in your letter to request notification is important there because you might not otherwise have as much public notice on a case when there's an addendum. So prior to preparing the draft EIR, the agency, they do a notice of preparation, and this is giving the public a period to comment on what the scope of the EIR should be, what impacts the public thinks need to be addressed in the EIR, and it's also a great opportunity to suggest alternatives that should be studied in the EIR. They're not absolutely required to analyze those, but it's a really great opportunity. If you think a project's going to have an impact on a historic resource, you should add that. In the scoping period, it would be great to suggest a preservation alternative. And scoping meetings are not always required, but for larger projects, agencies usually do hold those, and that's also an opportunity to provide comments. So after they've gotten the scoping comments and prepared the draft EIR, the agency issues a notice of completion of the EIR that you can get if you've requested notice, or it'll be posted in other places as well. And the notice will give you some brief information and where to find the draft EIR. And then this will kick off the usually 30 to 45 day comment period on an EIR. I've definitely seen longer than that, but there need to be special circumstances for that. And yes, just going back on that, during that comment period, it's really important to get comments in during that, because any comments that the public provides during that comment period, the agency is required to respond to. So some key elements of an EIR. A statement of project objectives, that's very important because it defines what alternatives are going to be considered and what is considered feasible and infeasible as far as what can be done for the project to eliminate impacts. Again, the baseline needs to be considered and the whole of the project needs to be disclosed. Impacts, including the cumulative and growth inducing. There needs to be analysis of alternatives. There does not need to be an analysis of alternatives in negative declarations and MNDs, but there does in EIRs. And then mitigation measures need to be included for those impacts that might be significant as well. I think Deborah's going to talk a little bit more about alternatives, but just briefly what's required. An EIR is required to consider a reasonable range of alternatives. There isn't a set number that needs to be studied. The no project alternative definitely needs to be analyzed. If there are impacts that are very specific to the location of the project, you're proposing to build on a wetland. There's other sites all around that are not wetlands. You should analyze, the agencies should analyze alternative locations in addition to alternative configurations of the project. CEQA also requires that the alternatives analysis identify the environmentally superior alternative, which alternative is going to have the fewest impacts. And in general, that's going to be the no project alternative. But if that's the case, then the EIR also has to identify the next best alternative, environmentally superior alternative. And again, I always tell folks it's very important to comment on the alternatives and suggest others. If there's something about the project that you don't like, don't just say you don't like it. Suggest other ways to make the project work. If you have suggestions for ways to work a historic building into a larger project that is being considered, that's very important to do, and providing as much information as possible to the agency so that they can see the potential for that can be very helpful, both for getting a better project and possibly setting yourself up for a stronger litigation position. After the comment period, the agency takes those comments and prepares responses and then revises the EIR. Generally, in response to comments, there are some changes that need to be made to the EIR. Sometimes there are changes to the project in the interim that the applicant has proposed or the city has requested. Those need to be revised in the EIR. And if those revisions are very significant, they're disclosing new significant impacts or increased significance of an impact they'd already identified, they need to recirculate the EIR for more comments so that the public always has an opportunity to comment on those significant components of the project. And then the final EIR should also identify, after all of these changes have been made and the comments have been responded to, what are, if any, significant and unavoidable impacts. There are the significant impacts that can be mitigated to a less than significant level, and there are these others that are considered the significant and unavoidable. And the final EIR does not need to be circulated for public comment. It needs to be made available before the project is approved. We have seen it be made available as part of the staff report just a few days before project approval, but usually it's provided earlier and can be reviewed to see if comments have been adequately responded to and there are any significant changes to the project. There are several steps in the post-EIR process. There's the certification of the final EIR, findings for each of the impacts, the statement of overriding considerations potentially, mitigation monitoring reporting plan, and then the notice of determination. So I'm just going to go through each of these in a little more detail. So, like I mentioned earlier, the agency doesn't have to prepare the EIR itself, but it does have to certify that the findings of the EIR, they agree with them in their independent judgment. They have to have reviewed it, considered it, and found it to be correct, and was completed in compliance with CEQA. And they can't delegate that duty to do that to a different agency or a more inferior, the City Council, if they're required to approve the project, they can't just say, well, the Planning Commission looked at the EIR, they said it was fine, we're good with it. They have to certify it themselves. For each of the impacts that, the potentially significant impacts that a project might have, the agency is required to make findings. So they either have to find that the project has been changed to avoid or substantially reduce the impacts. They've adopted an alternative or they have put in mitigation measures so that the impacts are no longer significant and unavoidable. If they've done that to the extent they can and the impacts are still significant, they need to then make findings that there are specific economic, social, legal, technical, or other considerations that make mitigation measures or alternatives infeasible. So if there is something that could be done to eliminate an impact, but they say, well, it's too expensive, that's where they would go with this finding. And to unpack that part a little bit more comes with the discussion of the statement of overriding considerations. And this is used when a project would have an unavoidable and significant impact. As I stated at the beginning, CEQA doesn't guarantee that all impacts will be eliminated from a project, but it does guarantee that all will be disclosed to the public, to the decision makers, and the decision makers will find that there's no way to mitigate or eliminate those impacts. The feasibility finding with regards to economic feasibility, just another point on the Uphold Our Heritage case, one thing they found there was the developer had looked at what the cost of demolition was and what the cost of building a new home was. And they said, well, they looked at the cost of rehabbing the historic home and the cost of building a new home. And they said, well, it's much cheaper to build a new home than it is to rehab this home. But the court said you have to look at all factors there. And if you're going to build the new home, there would be demolition that's part of it as well. And you need to consider all of those factors when you're comparing the costs. You need to have an apples to apples comparison for the economic feasibility component. It's also not just the project would make less money. It needs to make so much less money that it would not be profitable or feasible to go forward with the project. And evidence that's been found to support that in case law is a letter from a lender that said we won't loan them money if this is all the housing that you're going to allow under for this project. They need a larger project to make this economically feasible. Something outside of just the developer saying we won't make enough money. Legal feasibility, that was another issue that was debated in the Uphold Our Heritage case, and the real party argued that, well, you can't force us to do the preservation alternative, so it's not a legally feasible alternative. And the court said that's not what legally feasible means. It means that, is it something legal to do, the project that we're proposing? Whether you decide to do it or not is irrelevant. An agency can approve a preservation alternative knowing full well that the real party, the developer, is not going to go forward with it. And that isn't the relevant consideration. They approve what they think is a feasible alternative. And then one area where this feasibility finding gets a little bit fuzzy as well is the policy reasons for finding an alternative to be infeasible. Oftentimes that's about not meeting project objectives. And there is an issue when a project has a very specific project objectives. We need to build 10,000 square feet of space at this specific location with these specific setbacks. That's so specific that you can't consider any alternatives, and it's too narrow. And courts have found that that's not, you can't rely on project alternative or project objectives such as that to eliminate alternatives to a project. And briefly, an additional component that needs to be adopted at the end of the process is the mitigation monitoring reporting program. And this is to ensure that those mitigation measures can't be deferred and that they're actually going to be enforced. So this is a plan for what are the mitigation measures to eliminate the impacts, who's responsible for enforcing them, when are they going to happen, and who is going to make them happen. And having that in place is intended to help ensure that these conditions are actually followed. I'll just touch briefly on a couple of historic preservation federal laws. NEPA, Section 106, Section 4F. NEPA, as I mentioned at the beginning, is what CEQA was based upon. They are very similar in a lot of ways. NEPA applies to major federal actions. And in NEPA, an environmental assessment, or an EA, is the equivalent to an extent of the negative declaration in CEQA, except that under NEPA, EAs are required to study alternatives. There is the finding of no significant impact or mitigated finding of no significant impact. And I guess, let me step back and say, an EA is actually a little more akin to an initial study, and the FONSI and mitigated FONSI are more of a negative declaration or a mitigated negative declaration. And then the equivalent to an EIR in the NEPA process is the EIS, the Environmental Impact Statement. And for a project that requires both federal and state approval, frequently there will be a joint EIR, EIS prepared. Federal agencies cannot after the fact, rely on a CEQA document that was prepared. They have to have their own document prepared. So they can't, like a responsible agency under CEQA can just use an EAR that the lead agency prepared. A federal agency can't do that. And then one other major difference between NEPA and CEQA is the substantive mandate, and that's the under CEQA, you can't approve a project if there are feasible alternatives. And we discussed the ways feasibility is determined. Under NEPA, there isn't that same prohibition on approving a project if there are feasible alternatives. You need to analyze the alternatives, you need to disclose all the impacts, but even if there are feasible alternatives, you can sometimes approve a project that would have an impact. Under the National Historic Preservation Act, Section 106 is when there is a resource that's going to be impacting, or when there's a project that's going to be impacting a National Register eligible site, federal agencies are required to take that impact into consideration and consult with SHPO and the Advisory Council on Historic Preservation. And the intent of that consultation is for both parties to identify the impacts, they identify the scope of how many resources are being impacted, and to identify mitigation measures and find ways to reduce those impacts. And the intent is for that consultation to result in a Memorandum of Understanding, MOA. But there isn't a requirement that there be any specific, if SHPO really wanted the project to eliminate a portion of the impact, but through consultation the federal agency doesn't agree to that, it can still be approved under Section 106. Section 106 just requires them to go through this process, which is intended to help really suss out the impacts and make the agency consider ways to reduce those. And then finally, Section 4F. This only applies to U.S. Department of Transportation projects, frequently applies to Caltrans projects because they get funding from the U.S. Department of Transportation. And it is very strict. It does have a substantive mandate similar to CEQA. And it's intended to protect historic resources and park resources. And you can only approve a transportation program or project if it's going to have an impact on a historic site or a park, if there are no prudent or feasible alternatives to using that land, and that the project has included all possible planning to minimize the harm. And this only applies to historic resources that are National Register eligible. If a resource is just a locally designated resource that hasn't been found to be National Register eligible, Section 4F wouldn't apply. And Section 4F also applies to constructive use. If you're going to build a freeway 10 feet from a historic house, there is a constructive use aspect to it. You're not demolishing it, but you're essentially making it unusable by altering its setting and its available use. And that concludes what I had put together, and we have time for questions.
Right on time, actually. 3:10 exactly. So we have 5 minutes for questions. I don't see any questions come in online yet, so we'll start with the audience here.
Hi, Amy. First, let me thank you for making yourself available and a great presentation for all of us. CEQA is known for very short timelines, and you mentioned, especially when agencies are using, say, addendums, the audience or the public might not ever get an idea of when that's being prepared, and they won't understand until the project's being constructed or expanded that there might be a substantial change to a project that might need a review. Can you just talk about and inform the public about perhaps the discovery rule and that when those timelines are triggered, that might give petitioners or the community some little leniency on those really harsh statute of limitations?
Sure. Well, first off, if a notice of determination isn't prepared after the fact, then there is, instead of the 30-day statute of limitations, there's 180 days. If there are changes to the project from what was disclosed in the EIR, addendum, whatever document, a recent example of this is a case that Susan brought successfully recently on an addendum. A hospital was being proposed to be built, and everything disclosed that it was going to be 70 feet tall. All the environmental review documents said it would be 70 feet tall. Well, they built it and it was 90 feet tall. And nobody knew that until it was completed. And so they were allowed to bring litigation after the fact because there was no way for them to have had an opportunity to comment on the impacts of a 90-foot tall building before then.
Follow up on that. I believe the court said that in that situation, mitigation was only feasible. You're not going to knock down a brand new building. And they remanded the case for proposed mitigation. And I wish Susan was
Yeah, I know. I'm
going to follow up.
right.
Do you have any idea of what those mitigations were proposed and adopted by the trial?
I actually do not have
Good
that.
call,
Yeah.
Susan.
Yes.